Hello everyone and welcome to Llinks Law Office's webinar series, How to Establish and Safeguard Corporations in China. Part 4, Safeguard Intellectual Property in China. My name is Erin Wang and I'm working as the marketing manager here at Llinks Law Offices. I'm excited to be hosting today's session. In today's webinar, our speaker, Xin Yang, will help to explore the features of the IP legal system in China, analyzing the challenges businesses encountered in enforcing your IP rights in China, discussing practical solutions to safeguard IP assets when conducting business in China. Xin Yang is from Llinks Law Shanghai office. The webinar comprises of 40 minutes of presentation and 20 minutes of Q&A session at the end. If you have a question for our speaker, please feel free to send it through the Q&A tab at the bottom of your Zoom player. We will be answering questions at the end of the session. If we don't get to your question during today's webinar, we will be sure to follow up afterwards. We will also share webinar PPT and audio recording with you after the webinar. Now, without any further ado, I would like to kick things off by welcoming our speaker, Xin Yang. Xin, now over to you.
Thank you, Ariel. Good morning, good afternoon, ladies and gentlemen. Now imagine you are contemplating doing business with China. What is your most valuable assets? What will attract your business partners or consumers in China? Now, Chinese companies, they do have money and they have access to a large talent pool, but they do want technology and your intellectual property rights. So probably your intellectual property rights, your technology is your most valuable assets in the China market. So when you invest your IP rights into China market, do you fear that your IP assets will be lost in the vast market? Do you fear that your IP rights will lose control? Now, can you use a UK standard agreement to protect your IP rights in China? Or were you willing to design an IP protection strategy suitable for the China business? Now, this will be the topic of today's webinar, how to safeguard your intellectual properties in China. By way of introduction, I have 16 years experience in working on commercial IP and technology. Now I'm leading the commercial IP and technology practice at Llinks. Before I joined Llinks, I worked for the Shanghai, Hong Kong, London offices for Freshfields, Brookhouse, Ranger, and Simmons, and having a particular focus on cross-border IP protection, IP transactions. During this seminar, I'd like to discuss the following 4 topics. Number 1, what are the key features of PRC IP protection systems? How it is different from the UK system? And number 2, how to design a transactional structure to protect your IP in China. Number 3, how to draft IP provisions in commercial contracts. And number 4, how to design an IP enforcement strategy. Now, let's first have an overview of PRC IP protection system. How PRC legal system is different from English law system. Now, China is a civil law country, which means we rely on statutes, the written rules. As far as IP law is concerned, the scope of IP protection, the definition of IP, the mechanism to protect intellectual properties are all defined in the written laws. We need to look into these laws to ascertain how and what IP is protected. Now, different from the UK law, we do not have equity law or common law concept of rights. So there are no common law intellectual property rights. We only have statutory IP rights. We do have a very diversified source of law. It's not one piece of patent code or one piece of trademark code. We have a lot of legislations. Let's see the chart. if you can see, at highest level, we have basic Congress-made laws. And below that, we have other Congress-made laws, and also the administrative regulations issued by the State Council, and also ministerial rules to supplement or implement the supreme regulations and laws. Judicial interpretation, which is the interpretations issued by Supreme People's Court, they interpreted a number of detailed issues relating to IP laws. Now, this chart does not exhaust all legislations, all sources of laws in the IP area. This is only for illustration purpose. So as you can see, now we cannot rely on one piece of legislation. We need to look into all the legal legislations, all complete picture of the laws in determining a piece of IP issues. Now, what are the key features of IP rules? Of course, there are a lot of PRC law features, but I believe the number one item you need to remember is registration of IP right is the king, is the most important concept in the PRC IP protection region. Every items of IP rights, which is required, either required or recommended to be registered in China in order to receive protection. Now, of course, patent must be registered and approved in China in order to be registered, in order to be protected. Okay. Design, we have design patent, which is also need to be registered in China in order to be protected. There is no concept of unregistered designs in the same way in UK or in other part of Europe. Now, trademarks need to be registered in order to be protected. Although the PRC laws do offer limited protection on well-known trademarks, but we do not have protections over general unregistered trademarks. No, we don't have that concept. Copyright, according to the PRC copyright law, is protected upon creation. There's no mandatory registration requirement. However, copyright registration is still highly recommended for a number of reasons. Number one, copyright registration is a prima facie evidence of copyright ownership. So you can present to the court or administrative bureau the copyright registration certificate to prove that you are the copyright owner. This is the best way to prove. And number two, the copyright registration owner certificate is a precondition to receive an administrative protection on your copyright. So when the government conduct a marketing campaign to fight against counterfeit copies, they only take actions against those infringers infringing registered copyrighted works. The reason is obvious. If there's no registration of copyright, the government does not know which works are infringing and which works are generous copyrighted works. And also important, a licensing agreement, a copyright licenses and copyright assignments need also to be filed. Now, we'll come to more detail later. Now, number two feature is, in China, the IP law, intellectual property laws, is still in an emerging area. Now, this means the rules are still in the process of being developed. We can see some inconsistent cases, judgment issued by the court, but they have dynamic nature. By reading the rule, by reading the decisions, we can see how the court is thinking about emerging IP issues. Now, as we mentioned before, the scope of IP protection must rely on the written rules. But during the emerging area, there are a lot of new concepts. For example, the data rights, the rights in the data. How these new items can be protected? We have catch-all provisions and unfair competition laws. Now, sometimes and usually we can cite these magic anti-fair competition laws to protect some type of creations which is not explicitly protected under other IP laws. Generally speaking, the anti-competition laws, they can prevent those companies who hitchhiking other parties' creations in doing a competing business or otherwise prejudicing to the right owner's business. Now, come to the enforcement of IP rights. If our IP rights is infringed by a third party, how we can protect our interest, how we can fight against the infringers. Number one issue we should remember is the PRC IP enforcing system is a bifurcated system. So the infringement and validity issues are determined according to a different procedure. Now, in a lot of cases, when a plaintiff initiates an infringement proceeding in a civil court, most likely the defendant will challenge the validity of the underlying patent or underlying trademark at the Trademark Bureau or the Patent Bureau. Now, this is a different procedure. So whenever we try to enforce our right, we need to prepare at the initial stage that the possibility that the defendant will challenge our IP right in a different proceeding. Now, to the judicial system. Now, when we're dealing with IP infringement, most likely we'll initiate a suit with the court. In China, we have specialized IP courts and IP tribunals. These courts and tribunals, they have a lot of experience, and their only work is to try IP-related cases. As to some patent cases or trade secret cases where there are a lot of technical issues, the judges will be assisted by technical experts. However, there are no discovery procedures. So as we will discuss later, the evidence collection is still very difficult in China to the IP enforcement proceedings. In IP infringement cases, final injunction is always available or usually available for the parties. But the interim relief is very difficult. Now, the concept here is the judge must establish a clear case in order to issue an interim relief. They usually think for the business, mandatory damages is good enough to award the damages, award the compensations. And interim relief will probably prejudice to the defendant's business. In the trademark infringement cases, copyright infringement cases, usually interim relief is relatively easier, but it's very difficult in patent cases, and even more difficult in trade secret cases, because the court cannot see from the surface of a case whether this is a good case, especially there are a lot of technical difficulties involved. Now, people in China often refer to administrative systems to seek quick injunctions or quick remedies. It is true that an administrative system offers fast decisions. They raise very fast comparing to the court, but they can only handle straightforward cases, especially trademark cases and some copyright cases. They can compare from the surface whether a third party is using a trademark identical to a registered trademark. But in patent cases, especially those cases involve a lot of technical discussions, they can't do that. Trade secrets is even more difficult because the government cannot determine from the surface of case whether a piece of information is confidential. Now, this is only a very brief overview of PRC IP protection system. And the message here I'd like everybody to remember is the PRC law is different. We need a different strategy to protect our IP right in China. And very importantly, registration. Try to register all pieces of your IP rights in China before you enter into the China market. Now, let's move to the second topic, how to design a transactional structure to protect your IP. Now, let's imagine we have some valuable IP assets in UK or other part of China, other part of the world, and you want to expand our business into China. The first thing that we need to register our IP in China. Okay, and number two, when we have our right ready in China, we maybe need to find a business partner which have a business, distribution channel or have manufacturing capacity to help us to build up our business in China by using our technology or IP rights. And then we need to perform, we need to design our transactional structure to find a suitable structure for entering into business in China. And then we need to have some agreements to document our structure. Now, first, we need to file our IP right in China. There are a lot of factors we need to consider. What marks, what patent we need to register with the China government. What kind of IP assets we need to bring into China. Now, let's just discuss some unique issues. Trademark. If we have a very successful brand in UK, we want to expand the brand business into China. And number one issue we need to think about is to select a Chinese mark which is suitable for the China market. Now we know Chinese people speak Chinese. Although many Chinese people can understand English, but the daily life language is still Chinese. So if you do not have a Chinese brand in China, most likely Chinese consumers or Chinese customers will create a Chinese brand for you, over which you will lose control. I'll give you an example. Remember the Pfizer case? Pfizer, the pharmaceutical company, they have a very successful product, Viagra. Okay. Now, when the Viagra is known to the Chinese market, the news reporters create a name for Viagra, Wei Ge, meaning the great man. It's a super brand, but Pfizer does not realize the value of the brand. They did not register brand in China. As a result, another Chinese company, a Chinese pharmaceutical company, registered the brand Wei Ge, great man in China. And Pfizer has no control, had no right in such a good name, although the name originally was used to refer to their product. Now, this example gives you a clear idea, the importance of create a Chinese name for your brand. Now, some people want to migrate your English brand into China. That's fine, but we need to bear in mind that we do have some additional restrictions comparing to the UK trademark system. So, some more restrictions on the registration of mark in China. For example, Tesco has the brand Finest. Okay, it refers to supreme quality food product, Finest. However, in China, we cannot register a superlative description as a trademark because under the advertisement law, so the use of superlative is considered misleading use of description. So you cannot register that brand and you cannot use that for promotion purpose. So you will have to, if you are using a superlative of the brand in UK, you will have to create another name, even an English name, for your product in China. Okay. And also importantly, although the UK and China adopt a similar classifications of goods and services on which trademark will be registered, but the detailed classifications are different. There are some items on which you register trademark in UK that not have corresponding items in China. So we need to design what item to be registered in China separately under the PRC law. Now, as a patent, we need to remember that the patent system in China is somehow different from UK. We are more similar to the German patent law system. For example, we have a utility model patents. We refer to a kind of creation which is less inventive and receive a shorter period of protection, but still a patent. The patent owner still enjoy the patent right. Now, this type of patent is very important for foreign companies when they first doing business in China. Now, I've seen a lot of Western companies. They have a full patent folio in Europe, in UK, and in the States. But when they come to China, the most original patent has already entered into public domain. They have to file a secondary patent in China. This patent usually has lower level of innovation and a lower level of inventiveness. Now, in that case, it will be advisable to consider to file a utility model patent in China to receive a quick and not longer period, but still a patent protection. And also for pharmaceutical companies. Now, you need to consider the supplemental data issues. In the UK law, UK patent law, and in the US patent laws, the admission of supplemental data to support a pharmaceutical patent is allowed. But in China, the general rule is not allowed unless the supplemental data is obvious for the skilled person in the art. Now, according to the US and China Economic Trading Treaty, which the two countries signed in January this year, China will begin to allow admission of supplemental data to prove the inventiveness or sufficient disclosure of a patent. But we're still in the stage of developing these supplemental data rules. We have seen a lot of cases where a patent filed through a PCT, the Patent Cooperation Treaty, into China. When we try to enforce the patent in China against the infringer challenged the sufficient disclosure requirement of our patent because some of the data disclosed in the description of the existing patent is not enough according to the China standard, and supplemental data was not allowed at that time. So this is the issue we need to consider when we're filing a patent in China. Now, let's move on to the transactional structure issue. There are a lot of factors need to be considered when designing a transactional structure. Number one, the IP, the technology itself, whether the piece of technology is patentable, and the life cycle of the product, which determines how easily a third party can infringe, can misuse our technology. And in turn, it will determine whether we need to hold this piece of technology in our hand without releasing to the market. And number two issue we need to consider is the regulatory requirement. If you are entering into a value-added telecoms business, for example, there are statutory requirements that certain type of IP rights need to be transferred to the licensed company in China, to the media business, for example. You also need to consider transfer some IP rights, the copyright in the movie or in a cartoon to a Chinese company in order to have a better treatment by the government. And also, if you are engaging in research and development involving genetic resources, there are requirements for you to share your IP rights with your business partners. Now, these regulatory issues are something we cannot avoid. We also need to consider the market competitive position. Is it a niche market with just a few players, or this is a market with a lot of players, which will increase the risk of your technology being misused? And also, how good your partner is. Do they have a good track record? Are their main business is the same as you or competing with you? Or for example, if they are only engaging in a distribution business, they will unlikely stealing your trade secrets or your technology, because they can derive the bulk of the revenue from their own distribution business. Now, by understanding analyzing these factors, we can think about the transaction models. Typically, we have a supply distribution model, okay, where you supply the product to a distributor in China, and for them to distribute your products into China market. You may also have a licensing model, where you grant a license to your business partner for them to manufacture products or providing services in China, in the China market. And you also can make, you may also consider establishing a joint venture with your business partner. Now, a lot of people will think of, if we enter into a supply distribution model, it is the safest because you can have everything holding in your hand. Now, all the products in your hand, all the IP rights in your hand. Is that true? Probably not. It all depends on the circumstance. Let me give you an example. When a medical device company, when they enter into China market, they appoint a distributor to distribute their medical device. However, a few years later, they find out that the so-called distributor actually has its own manufacturing business, manufacturing the same type of medical device. Now, through the distribution of the UK company's medical device, they know the market, know the market better, and they successfully design a product bypassing the patent, and they do reverse engineering works to know a lot of know-how of the UK company's trade secret, technical secrets. And then now they have established a competing business channel, distribution channel, competing business. So in the supply distribution model, although conceptually the UK company hold the product, hold the technology at hand, they are still losing their IP rights. Because IP rights, intellectual property rights, are not something physical you can physically hold in. It's intangible. When the product is released to the market, there will be a risk of being disclosed and misused. Now, let me give you another example. That's a US company. They are engaging in manufacturing of certain type of equipment for vehicles. They have established a joint venture with a Chinese company, which also in the vehicle business. Now we help the establishment of the business, and until now, it has already been 10 years, and business runs very successful. No party is trying to leverage the other party's trade secret. Why? Because they view the joint venture as their baby. No party is trying to steal the other party, and they have no incentive to steal other parties' trade secret or intellectual property rights. They are bound by the joint venture agreement not to enter into a competing business. So sometimes when you invest your IP rights into a joint venture, conceptually, it will bind the parties together. This kind of model is particularly advisable in the business where the Chinese party can quickly learn your technology, and the technology is difficult to be protected by patents, especially engineering design business. Right? Every design is different. It can only be protected by know-how. Now, although you cannot patent the design, a lot of information can be learned by the party, but by using a joint venture structure, the parties will more respect the other party's trade secret and technical secret. Now, I would say every transactional structure is different. There are no unique rules. We need to consider the structure issues on a case-by-case basis. Now, let's move to the third topic, how to draft IP provisions in commercial contracts. Understand, we like our own template, even if it's governed by UK law or draft based on UK standard. But we need to consider the PRC law issues, PRC practice in drafting IP provisions in commercial contract in order to better protect our IP assets. Now, what contracts need to consider IP issues? I will say all contracts may have an IP angle. NDA, non-disclosure agreement, licensing agreement, IP assignment, of course, these agreements have an IP angle. And also, joint venture agreement may targeting the technical issues. The reason for establishing joint venture is technology, right? Distribution agreement will deal with the use of brand. Manufacturing agreement may deal with the use of manufacturing know-how. A sponsorship agreement also deal with the brand or goodwill. Now, obviously, contract may have an IP issue. NDA, non-disclosure agreement, is usually considered the simplest IP agreement, but still have a lot of issues to be discussed. Now, let's see the first issue about definition of confidential information. Let's see an example. The term confidential information should mean the trade secrets and other confidential information of a group member which is not generally known to the public and which is discussed, disclosed, or revealed during the conference. Now, is this a good definition? Of course, this is a right one, but it's not the best one. This definition captures a broad range of information defined as confidential information. However, if we are seeking preliminary injunction to a court, now, when we present this provision to the court, what will the court think? We present the NDA and a piece of information which claim that the party is infringing. What will the court think? Court will think, well, I know you have NDA, but I do not know whether the piece of information you claim the other party is infringing fall within the scope of confidential information as defined in the NDA. So the court will be reluctant to grant interim relief. Now, how to improve this provision? A better way is to give some examples according to the circumstances. For example, if we are discussing a potential project, we'll say the technical secret or a drawing of a product disclosed during the communication is considered confidential information. Now, if we have that kind of examples included in the NDA, the court will have a better idea about whether the piece of information you present to the court is confidential. We do not have many cases where trade secret cases where court granted interim relief, but in most of the cases, most of the decisions which I have seen, the plaintiff has demonstrated to the court that the piece of information which the claim to be infringing is fall within the scope of definition, fall within the definition of confidential information defined in the NDA. Okay, this one issue. Now, let's think about governing law and dispute resolution clause. I have seen some NDAs will be governed by English law and subject to an English court. Now, number one, we cannot subject NDA to an English court in order to be enforced in China. English court judgment will not be automatically recognized and enforceable in China. Okay, we probably need to have a PRC law, PRC court to trial the issue. Number two, can we have the NDA be governed by English law? Well, of course, theoretically speaking, we can. For foreign-related contract, where the one party is a foreign party, we can select a foreign law, including English law. However, this is not the best way. when we present the NDA governed by English law to the court for a preliminary injunction, the court may think, well, this is an English law governed contract, but we do not know the English law. They will ask, for example, they think, oh, this is unilateral NDA. But I remember, consideration is necessary to enforce a contract under English law. So whether this NDA is enforceable in the English law, they probably will ask the plaintiff to prove the English law, which will delay the process. So if the NDA is governed by Chinese law, then the court will have no excuse to delay the review of the contract. Now, the same reason applies to the language issue. Now, if the NDA is only written in English, then the court will ask you to have the agreement to translate it by a certified translator. So this will delay the process. So ideally, we should have a bilingual version of NDA or other type of IP agreements. Now let's come to the IP issues in the assignment. The first issue to be considered is who is the right owner. Again, let me give you an example. A few years ago, Apple purchased the iPad trademark from ProView, another company engaged in the manufacturing of PC tablet. However, they didn't notice that the iPad trademark in China was registered under a subsidiary of ProView Taiwan. It's registered under the name of ProView Shenzhen, a subsidiary. As a result, the iPad trademark in China failed to be transferred to Apple. Now, when ProView entered into the bankruptcy procedure and the creditor take control of ProView, they initiate infringement action against Apple, saying, hey, the iPad trademark has never assigned to you, and now you are infringing iPad trademark as an infringement. As a result, Apple paid $6 million to buy the iPad trademark in China. So this example illustrates the importance of finding out who is the right owner. Now, we do not have the concept of beneficiary ownership. Merely a trademark assignment agreement does not mean that the assignment of the trademark itself or other type of IP right itself. The successful assignment of trademark or patents need to record it with the government. The assignment became effective only upon the completion of the assignment. Now, also the IP license agreement need also to be filed. Now, the filing has two purposes. One is this is a kind of administrative requirement. You need to file it. And number two, the filing is a proof of legitimate use. For example, if you license a third party to use your trademark, if 3 years later a third party try to cancel your trademark based on 3 years non-use doctrine, you need to produce to the court that there are a licensee use the trademark under your control. In which case, you need to present to the court and the trademark license agreement to prove your point. Now, also in the PRC law, there are a number of restrictive provisions or mandatory provisions which need to be considered. For example, you cannot require the licensee to surrender their improvement to the licensor, or you cannot make a tile sale to require the licensee to purchase some other necessary products from the licensor. These provisions are quite similar to the EU Block Exemption Act. Now, due to time limitation, I will not go into the details. And also, there are some mandatory warranties which licensor need to provide to the licensee, including the warranty of the title and the warranty of the quality. Sometimes we can see the provisions, the example here, the licensor will disclaim all warranties, guarantees, and conditions, whatever. But these provisions is not enforceable in the PRC law. Especially the PRC court will likely to consider you only carve out the additional warranties outside the scope of the mandatory warranties. Now, in order to achieve the purpose to give limited warranties, you need to look into the details, look into the circumstance. For example, if you are licensed a software, according to the industrial practice, you cannot warrant it free of virus. So you need to make it specific to say, now, this is a software, we are licensed to you. To the quality, I scanned this software by using the common used antivirus software, but we cannot warrant it's free of virus. Now, this kind of very specific language to qualify our warranty. You cannot generally say it's warranty free. Now, some people will discuss about the distribution agreement. Want to divide the market, saying when we appoint a distributor in China, we want to restrict certain kind of activities. For example, we appoint a distributor only can distribute products in Shanghai, but not outside of Shanghai. Now, we cannot divide the retailing market. This will violate the antitrust law. However, we can have some other mechanism to achieve the business purpose. For example, we can use a KPI to encourage the distributor to distribute the product within an area which we encourage them to do. And we can also license commercial trademark to them to require them to only promote your product within Shanghai, not other part of Shanghai. So when they're using our licensed brand, they can only use our licensed brand for the business within Shanghai, but we did not prohibit them to sell the product incidentally outside of Shanghai. Now I need to skip a number of pages due to time limitations. Now let's move to the last section. How to design an IP enforcement strategy. That is, when we discover there are third party infringe our IP rights, how we can fight against them. There are a lot of tools in the PRC to use to fight against infringer. But before that, we need to think about a number of issues to design our strategy. Number one, the purpose. Of course, we want to exclude competitors outside the market, and we also want to get damages. But what is primary purpose? Do you want to get money or to exclude the competitor from the market? And then we need to study the infringing patterns. There are a lot of small players. They distribute the infringing products through a single or a primary channel, or they're only just a big manufacturer and distribute the products through a lot of small channels. Then we can select right way, right strategy, right target to fight against. And we also need to think about the availability of evidence, as that the evidence is very important in a civil proceeding. How we can collect evidence. Probably it will be difficult for us to directly find out the manufacturer. And it will be easier to get infringing products to be investigated from distributors. Then probably we can first target the distributor and have them to bring the manufacturer into the case. And we also need to think about the possible grounds for us to initiate a case. Now, we will talk about the possible grounds later. Some company will ask the question whether we need to send a warning letter before taking legal actions. Now, generally, a warning letter is not very effective in the same way as UK or US. Especially a lot of infringers, they will select to ignore a warning letter. But sometimes a warning letter is useful due to a number of reasons. Number one, if the infringer is considering IPO, now, a warning letter will be very effective because when they're doing IPO, they need to settle all disputes. Number two, when the other party is a big player in the market, they value their reputation, then a warning letter may probably bring them to a negotiation table. They will say, hey, we are not infringing, or they will say, let's try to cooperate. At that situation, a warning letter will be useful. Now, if a warning letter is not useful, or when we send out a warning letter, there's no response, then we need to initiate either a civil proceeding or an administrative proceeding or even a criminal proceeding. Now, in usual cases, we will trial our IP cases in a civil proceeding. This is the right court. However, sometimes using an administrative proceeding or even criminal proceeding will be more effective. Let me give you an example. This is a software infringement case. Now, because the other party is producing a competing software, the software is not disputed in the market, but is installing a machine where we have difficult to get the code of the software. In other words, it's very difficult for us to prove the copyright infringement. We suspect the infringer is infringing, but we do not have evidence. However, we find that there was an employee leaving the client company and joining the competitor. And we also discovered on the last day that employee downloaded certain type of source code and from the machine, from the server. Now, we filed the case as a trade secret infringement case with the police, and the police filed the case as a criminal case. Although, finally, because the only small piece of information are being stolen, okay, it's not amount to a criminal offense. But during the police investigation, the police has get a copy of the infringing code, and we then apply to the court to ask the police to give the court the copy of infringing software. Then it will be easier for us to establish a copyright case. Now, when we're doing the initiating a civil proceeding in China, I said the evidence collection is very difficult because we do not have a discovery procedure. But nowadays, we use some alternative ways to collect evidence, including use blockchain, e-discovery proceedings to preserving evidence. And also, we can apply for the court to ask the other party to give evidence. Now, in this situation, we at least need to establish a good case to show to the court that when the court asks the other party to give evidence, we will have a likelihood to success. In an MRI alerting system case, we video the operation of the system and show to the court that it will, if the other party has the same way of operation, they will likely infringe it. And then ask the court to ask the other party to present their infringing products. Some people will worry about local influence. Now, if we are trying a case in the defendant's province or city, where the court will more friendly to them. Well, it's a difficult question to answer, but there's a possibility. Now, I'm not saying that the other party will bribing the judge. That's very unlikely. But generally speaking, when the court is sitting in the city where the infringer is, and if the infringer is a big company, has a local influence, the judge will likely to think, oh, this is a good company. how can they infringing the other party's IP rights? That's kind of nature, human nature. Now, in this case, we need to think about to transfer the case into a neutral jurisdiction. Now, one way to get a neutral jurisdiction is to take evidence from exhibition. Now, in a case where the defendant is located in a small city in the mid to west part of China, we worried that we cannot get a fair trial in that city. But fortunately, we have seen that the defendant is participating in an exhibition in Shanghai. And then we preserve the evidence of their show in the exhibition, and based on the offer to sell, initiate a civil proceeding in Shanghai. Now, the last topic, alternative grounds. Now, sometimes we have very limited ground to sue an infringement, how we can find an alternative ground. Now, let's give you two examples. One example is a tooth printing case where the plaintiff is manufacturing and designing kind of tooth printing, 3D printing machine. And they realize that on the market, there are probably an infringing product. Now, because of the patent issue, the other party bypass the patented design. Now, at last, we find out in order for the device to work, the other party needs to use very similar or identical software. And the software is so identical that instead of establishing a patent infringement case, we have established a copyright case. Now, although the copyright is not core of the business, but the other party will necessarily copy the software in order to have their machine working. So we have a successful copyright case. In another example, it's a kind of testing slides. The slides will be put into a machine to have a healthy result, to show whether a human is healthy or not, or has a disease. The infringer reverse engineered our client's slides and produced their own version. Now, reverse engineering is legal, right? We can prevent the other parties to reverse engineer or to produce competing products. And the client does not have patent on the slides. They only have a patent on the machine. But the other party, they produce their competing slides to be used into the client's machine. Now, of course, this is a legitimate business, but what we have captured is the other party use a promotion wording that our products can be equally effective as the client's products, which violates the advertisement law. You just cannot compare the functions of two medical usage products. Now, so although this is not an IP infringement case, we stop the other party from using the promotion wording, our products is as effective as the client's products. We stop the other party's marketing activities and defeat their business model. Now this case illustrates we may have some alternative ground to fight against a co-in-co infringer, although this is not an IP case. Now, the takeaways. There are a lot of issues in the PRCIP IP protection system. And number one, we should remember is the PRCIP IP protection systems are different from the other part of the world. We need to take into the PRCIP law systems. And number two, IP protection starts with registrations. And number three, we need to remember that IP law is not only about the patent law, the trademark law, and the copyright law. IP protection requires the support from all the legal system, including anti-competition laws and attachment laws, etc. Now, here ends my presentation.
Okay, thank you very much, Xing. Let me quickly go through the questions. So, second, bear with me a sec. I'm looking through the questions. Okay, what kind of IP types exist in China?
Now, the IP system is very complicated. We have the commonly protected IP items in China, such as patent, the trademark, and copyright. And within the scope of patent, we have invention patent, which is very similar to the UK invention patent. And in addition, as we said, we have utility model patent, which is a lower level patent, and also design patent, which is very similar to the registered design in Europe. In addition to that, we also protect trade secrets, including technical secrets and operational secrets. A domain name, which is not an IP right per se, but they are also protecting China. Additionally, the trade name, which is protected as kind of entity right in China. And in addition, so there are some other items which can be protected under the competition law, including data. Now, we do not have a database right as Europe, but there are a number of cases established that if a party has a collection of data, they collect data by making a lot of investment or efforts, they can prevent other parties from using this data without its consent. So although the data is not intellectual property right per se, they are still protected as kind of intangible assets.
Okay, thank you. A few more questions from the audience. One question, could you please reiterate on the confidential information part that you mentioned?
Okay, yeah, I think the confidential information, this is a concept which attracts a lot of discussions globally. Now in China, confidential information itself is not an IP asset. It is protected under the unfair competition law. So in other words, we prohibit a business operator from stealing or misusing other parties' information, which the parties keep in confidential by proper measures. So we protect a good way of operation. Now, I do this. Originally, the most difficult part of enforcing confidential information is to get the evidence and to prove what are the technical features of the confidential information. Now, when we present, for example, an engineering drawing, we cannot say the drawing itself is confidential information. We need to identify the confidential features in the drawing. What's the points? Now, what points are considered confidential? This is usually the most difficult part of proving. Now, traditionally, usually we will engage a technical expert to do a comparison against the market to identify, now this part are not known in the market, and present the information to the court. Now, nowadays, we are trying to shift the burden of proof to the defendant. As from later last year, we amended infant competition law, and also according to the China-US Economic Trade Treaty. Now, the shift of the burden of proof will be shifted to the party if the plaintiff can generate prove that this design, for example, the design itself is not available in the market. Then it will come to the other party to prove that all the features they use has been in the public domain. So in that situation, the burden of proof on the plaintiff will be lower.
Okay, great. One more question. Did you say that reverse engineering is legal or not in China?
Okay, reverse engineering is legal in China, but subject to a number of conditions. Number one, the party doing reverse engineer must purchase the product on the market. Now, which means it must purchase the product on the public market. You cannot reverse engineer a product which the other party, for example, commission you to manufacture or commission you to repair. No, you have to purchase the product from the open market. Number one condition. Number two, you cannot infringe other right. So reverse engineering is only a defense to get confidential information, technical secret. But if a product is otherwise protected by copyright, you cannot infringe the copyright by saying, oh, I reverse engineer the product. And number three, the three condition is you cannot have the information first and to do the reverse engineer works to prove the information which you already get. You must truly get the confidential information through your reverse engineering works.
So reverse engineering in the sample that you mentioned, supply distribution was illegal?
In that situation, if the owner of the product, the manufacturer, has an anti-reverse engineering provisions in the agreement, then it can prohibit the distributor to perform reverse engineering works. But unfortunately, at that time, the company does not have anti-reverse engineering provisions.
Okay, so can we start filing for trademark registration and then prepare the documents later? Or is it obligatory to file the whole documents together?
Now, if you are doing a trademark deal, you at least need to have a trademark filed. It's not necessarily have the trademark registered, but you at least need to have a trademark filed. Otherwise, there will be risk that the agreement involving trademark will be considered invalid.
Okay, one last question. I registered my trademark in the UK and Europe. Is it valid in China?
The clear answer is no. The reason is all IP rights are subject to geographic restrictions. So a trademark registered in China, registered outside of China, is not valid in China.
Okay, do you have time for one more question?
Sure.
Okay, actually two questions. When is the best time to protect IP? How to adapt my trademark to the Chinese market?
No, for the timing issue, as early as possible. Now, there are a number of reasons is when you grow in your business in the China market, the players will likely know your business, and there is always a risk that they register your brand or register your other type of IP first. Then you will have difficulties to fight it back. I'm not saying impossible, but it will be difficult.
Oh, okay. Okay, last question. I've seen quite a few questions from the audience, but we don't have that much time left. So last question. Please explain about the refusal of trademark in China. So basically, we've got a client which his trademark has been refused by China IPO because of identical and similarities with another trademarks in China. Now the question is that can we solve it with adding some suffixes or prefixes to set trademark? Does it help?
Well, it may help, but I cannot ascertain this because it all depends on circumstances. In China, because China is a very large market, and there is lots of players in the market, and all of these players want to register some good names as their trademark in China, and this is only a single market. So if you search into the trademark office database, you can see a lot of trademarks have been registered, and very difficult to find a distinctive mark in the China market. Now, sometimes we can add some additions on the original trademarks to make it different. For example, PURA, this is a very popular name in Europe, and there are a lot of registration in China. But if we register my Pura, it's different. We do not have such name in China, and you can register it. And my Pura looks different from Pura, but no, it all depends on circumstances. And sometimes we can also consider using some artistic designs of the words, make it different. Make it not like a wording trademark, but a design. This will also help to distinguish ourselves from other brands.
Okay, I keep saying one more last question, but this is the actual, okay, the next question is actually the last question, okay, because we're already running out of time. Okay, so what can you do if you have missed the 12 months priority deadline to file Chinese utility model, as you were planning on filing Chinese patent through PRCIP? Is there is any provisional protection available before grant of the Chinese patent? For example, if successful, can damages be backdated, or can we retrospectively get Chinese utility model or speed up the Chinese PTC patent at CNIPA?
Okay, I think there are two questions. One is how to file utility model patents through PCT. The other is, if successful, can the damages be backdated? Number one is the PCT allows 24 months of priority date. So it's likely that you have sufficient time. But if you miss the 24 months deadline, there will be no solution. And number two is, now there are interim period between the filing of the patent until the grant of the patent. During that period of time, if a third party was using the patented technology, they are not considered as infringer. They're not infringing, but they will have the obligation to pay you a reasonable amount of royalties. We cannot say it's royalty, a reasonable amount of compensations for your technology, for the use of your technology. Now, if the parties cannot agree on the reasonable amount of the compensations, the party can appeal the case to the court to have the court decide the reasonable amount. Usually, that reasonable amount will be less than the actual royalty, because at that time the royalty, the patent has not been granted, but it's still a considerable amount of money.
Okay, great. Thank you very much for answering all the questions from the audience. Due to the time limitation, we have to wrap up the session. But if any audience member has any further questions, please feel free to contact our speaker Xunyang directly. You can see his contact information and the personal WeChat scan code up on the screen. And you can also see Llinks Law Office official WeChat account, which provides English and Chinese legal updates, analysis, and the market, Chinese legal market analysis on a regular basis. Okay, so Llinks Law Office webinar series have come to an end. I would like to thank you all again for participating in our webinars. Again, if you have any further questions regarding China's new investment law, labor law, data privacy law, and IP law, please feel free to contact our speakers directly. Thanks very much again for your support, and have a nice day.
Thank you.
Thank you.